what I'd like to talk about now is refusing to go back to work after you've been injured on the job. Now, there are two main categories for this. The first category is you have been hurt on the job, placed on work restrictions, and your employer has offered you work restrictions before you have ever received any indemnity benefits. And the second category is you have been injured on the job, you are receiving indemnity benefits. And when I say indemnity benefits, I mean you are receiving money on a weekly basis from the insurance company. And do you have to go back to work at that point? Now let's address the first one first. If you have been hurt on the job and your employer immediately offers you light duty work, you do have to attempt to perform that work. Now let's be clear. You need to be vocal about where you're experiencing pain and what type of pain you are experiencing, but you do have to go attempt to perform that work. If you don't want to go back to work, and it's quite understandable if you don't want to go back to work, then you may not be entitled to workers' compensation benefits, and it could make your claim a little bit more difficult. I would definitely contact an attorney at this point to discuss all the options you have available, including making a change of authorized treating physician to get a different opinion on your work status, and also maybe speaking with that doctor so they understand what the true nature of your job is. Now, if you are receiving indemnity benefits, the employer or insurance company has to go through a very specific set of protocols for you to return back to work. First of all, they have to provide the authorized treating physician with a form called a WC-240A. Now, a WC-240A is a list of restrictions that you can or cannot do at your job. Secondly, they have to provide a very specific job and job duties to your authorized treating physician who has to sign off on it. Now, if you go back to work, and they have to provide you with 10 days notice of when that job is going to start. Now, if you do go back to work, and you should go back to work, but you should definitely contact your attorney before you do go back to work, you have to perform that job for 8 hours or one whole workday. Now, if your employer sends you home, that's a different story. Now, after you've worked those 8 hours and you cannot return to work because of the pain or because of medication or some other reason, you need to inform your doctor right away, and workers' compensation benefits should recommence. However, it is never that simple, and I recommend contacting an attorney at that time so they can help your benefits restart, because the last thing you need is for bills to keep coming in and for you not to be receiving workers' compensation benefits. Now, there are a couple of key issues I want to discuss really quickly. First, do not assume that your employer does not have light duty work available for you. Many times in insurance contracts, the employer has to provide light duty work to injured workers. So I would definitely contact your employer to see if they have light duty work available after you have been hurt on the job and before you receive indemnity benefits. The second thing is, please contact an attorney before you refuse to go back to work. Sometimes we have clients who have been hurt on the job due to some type of traumatic incident, and because of this traumatic incident, they are afraid to return to their job, which is completely and totally understandable. But there could be a psychiatric component to this, to your claim, and therefore you should treat with a psychiatrist or a psychologist to get a further understanding of what your actual mental injuries are. Therefore, before you return to work of any kind, I recommend contacting an attorney, and here at Gerber & Holder, we are more than willing to help discuss these issues with you.